Welcome to your Key Discovery Point. I am Brett Burney from NextPoint, joined by Doug Austin of eDiscovery Today. Doug, another case that you covered recently was involving Amazon.com, and that is, could be any company basically, because there were some interesting pieces and factors here that came out of this case, specifically in regards to attorney-client privilege documents and the plaintiff asking for some documents to be produced, even where the court had to do an in-camera review, and the court was determining whether or not some documents were going to be produced. A little bit of a confusing, kind of an interesting case to navigate here, but I thought you did a wonderful job of covering it for us.
Oh, well, thanks, Brett. A couple of issues that were at play here. The first one was that the plaintiffs felt that Amazon had basically over-designated documents as privileged, and they filed a motion to compel. Amazon basically said initially, "Hey, we're doing a re-review. We're working on it." And so Judge Chun, a Washington District Judge, Judge Chun in this case, had basically said, "Okay, I'll deny it without prejudice. You can bring it. You can refile once they've completed their review, which they need to do by a certain date, and then I will review. You pick 100 documents for me to review on camera, and I'll review them." So the plaintiffs did that, and right off the bat, Amazon, with 15 of them, said, "Oh, we'll just go ahead and produce these." So they didn't even bother to, have Judge Chun review that. So the remaining ones, which is a little further down, I think, is the discussion on the because I kind of reversed them here. Right. The remaining 85 documents, he ultimately found that 54 documents. I was actually further down, Brett, and okay. Sorry, and go down to this area. There we go. Yeah. Yeah, that paragraph at the bottom. Basically, he ultimately determined 54 out of 85 documents reviewed in camera must be produced to plaintiffs in full or with some redactions. So It's interesting. He basically said 63 of the documents submitted for in-camera review must be provided to plaintiffs in their entirety or with appropriate redactions. But when you add in the 15 that Amazon just said, "Yeah, we'll go ahead and produce these," it was really 69 out of 100. So this is one of those cases where, unlike what Meatloaf would say, 2 out of 3 is bad, because you don't want 2 out of 3 of the documents you designate to not be privileged, or designating them as privileged. And one of the things that's key here is that a lot of the documents involved in-house attorneys as part of the communications. Right. But what Judge Chun differentiated was business advice or being part of business communications versus legal advice. Business advice is not privileged. You can't declare privilege on that. Legal advice, of course, you can. And one of the things that I think Judge Chun made clear is you can't just try to hide your business discussions by throwing an attorney on the CC list or what have you. Yeah. So that's one of the things I think is potentially what a lot of companies may do. They just may say, "Well, an in-house attorney is involved in this discussion. We're going to call it attorney client privilege or work product or what have you," when it's not necessarily so cut and dried. It will be interesting to see if if like Gen AI technology might help to differentiate the business versus the legal advice type of documents, and we'll see. But regardless, that's one of the things that I think you have to watch out for. If you are a producing party, you probably you should provide a bit more due diligence. If you're a requesting party, like the plaintiffs did here, you do want to kind of be able to call out the producing party to say, "Okay, make sure we're designating these right." If you think they're designating privilege too broadly, then you have to be prepared to kind of raise that issue. And the plaintiffs did a good job of that here. The other issue that was part of this ruling was that Amazon wanted to claw back 2 documents. that they had redacted partially, but then ultimately, I think, decided, well, we really just need to claw these back, altogether. And there was a little bit of a a misunderstanding on what the protective order really provided, because protective order, as Judge Chen stated, explicitly, it doesn't forego the Rule 502B waiver analysis, which requires basically protection, but only for inadvertent disclosures. Whereas Amazon said, the parties didn't intend to override the protections of Rule 502D. And what Judge Peck said, of course, he's the judge who's always saying, "Oh, you got to get your 502D order,"
That's right.
And they didn't really get an explicit one here, but their protective order kind of said a bit of both, which really didn't make any sense. You really have to be one or the other. So, with Judge Chen saying that Rule 502B waiver standard still applies. He said, well, their production was intentional. They did redactions. They produced it with those redactions. They can't then claw it back saying, oh, we judged it wrong and now we made a mistake. So he basically said they waived privilege on those documents. And so one of the things I think, of course, is an important lesson is if you really want to preserve maximum clawback capabilities, have a clear-cut Rule 502D order that enables you to do that.
Absolutely. And from more of a logistical aspect, it looks like in here that one of these documents, at least one of these documents, was produced like in 3 different production sets. I think is what they're talking about here, right? And in one of these 3 productions, there were different redactions or fewer redactions on this particular document. And so it's so important from a consistency standpoint to make sure that you know exactly. I mean, and the judge was able to pinpoint that because that doesn't look so good. Now, on the other hand, we both, you and I, have been on the other side where it's easy to say that to be consistent, but it's difficult when we're talking about, hundreds of thousands of documents and making sure that we're double checking everything. But I mean, I think a good litigation support professional would at least be mindful of that and making sure that we have those consistent productions. Again, not easy. I'm not pointing fingers, but I just know that was something that the judge pointed out, and that caught my eye from the support standpoint. It's like, oh yeah, you got to make sure that you're consistent along the same lines throughout the entirety of the case.
No, that's a great point, Brett. And one of the things that makes you wonder here is that are they, could it have been produced multiple times because maybe they weren't deduplicating at quite the level they could be? Because there are 100% dedupes that, is a pretty common practice. But then, you could have essentially the same document with just a little something different, or even a different format or what have you. And it's the dedupe filters aren't going to catch it. So then maybe it's something like a near dedupe might be necessary. So we do see that from time to time is that the document is produced multiple times. And it's the level of redactions could be different, which of course is not something. Inconsistency when it comes to privileged designations and redactions is not something you want to have. You want to avoid that as much as possible.
Absolutely. Key discovery point here. I mean, I feel like there's 3 or 4 consistency aspects, understanding the attorney-client privilege, at least specifically with regard to in-house counsel, and then just understanding the difference between a protective order and the Rule 502, the Federal Rule of Evidence 502B. A lot to go into this. You can read the entirety of the case again at Minerva 26, formerly e-discovery assistant. You always do a great job of linking to the entire case, Doug, so people can read a little bit more. And from a resource perspective, at Next Point, we have several e-guides, and one of them is Protecting a Client Attorney Privilege, 10 best practice rules for law firms of all sizes. If this is something that's a little bit newer, you want to make sure you get sort of a standard, a foundation on some of this, specifically when it comes to the e-discovery world. This is a great little guide that I'll make sure the link is in the show notes. As always, Doug, thanks for joining us, and we'll talk with you next time.
Thanks, Brett. Thanks, everybody.